6 months. In February of this year, we saw an executive order by the Biden administration that included, for example, a promise for rulemaking around a term of art in immigration called particular social group. In June 16th, we saw 2 twin decisions by the Attorney General vacating 2 earlier decisions around asylum and proposing and preferring a process for rulemaking. And then finally, just last week, on July 6th, the Department of Homeland Security signaled its intention to use notice and comment rulemaking to propose procedures that would shift some adjudications of asylum claims for those with a credible fear of persecution from immigration judges to asylum officers. So I hope that provides a good overview. And now I will turn it over to either Susan or Chris.
Thank you, Shoba. That was a great overview, at least for me. Chris.
Great. Well, so much fun to be here. And it's been a thrill this last year to be collaborating with Shoba on this project. And I would just start out by echoing, we, in the Duke Law Journal symposium issue last year, I'll put a link to that in the chat. Shoba and I wrote a paper where our bottom line is we argued that Chevron deference shouldn't apply in immigration adjudication, but should apply in rulemaking. And I'll kind of walk through some of the reasons why, but what's really undergirding that is an argument that immigration agencies and the president should shift the default for regulatory policy making for major immigration policy from adjudication and from these other tools Shoba just mentioned, interim final rulemaking, guidance, and why am I blanking on the third one? So what was the third one again?
Adjudications.
Oh,
Proclamation.
no. Oh, an executive order. Yeah, presidential directives. Yeah, that's right. And so we kind of flushed that out in there. And what we started writing this last summer before we, had any sense of what the election results would be. And then it was published shortly after the election. And one thing that we called on is for President Biden or whoever would be the president to nominate an attorney general that would commit to this, that would commit to shifting at least the default. That doesn't mean that everything needs to go through notice of comment rulemaking, but the default needs to switch. And as Shoba mentioned, really in immigration law and policy making at the agency level, it's really shifted away from notice of comment rulemaking and much more towards these other tools. Now, in our paper, our focus is on adjudication. And it builds on a paper by Aaron Nielsen and Kristen Hickman that I'll throw in the chat when I'm done, where they make a larger argument about how Chevron shouldn't apply or should apply more narrowly to adjudications than to rulemakings. And in ours, we decided to kind of do a deeper dive case study into immigration adjudication. And the reasons why, which we argue why Chevron shouldn't apply in adjudication and should apply in rulemaking, also I think are good reasons for shifting the default from adjudication or rulemaking for major immigration policy more generally. And when you think about Chevron, there are usually 4 main rationales that come forward for why we have Chevron deference. Agency expertise, comparative expertise compared to courts, right? That agencies have more expertise to implement the statute to make that policy decision. Political accountability or some type of accountability. Deliberative process, the types of process that agencies can use instead of courts. And then somewhat to a lesser extent, but I think it's important, uniformity in law. In other words, when an agency says what the law is, and it gets deference for that, it's gonna apply to the whole, federal system. Whereas if you leave it to courts, you might have a mishmash across the country until the Supreme Court weighs in. I'm not gonna focus on that last one too much, but I am gonna focus on expertise and process. And in our paper on the expertise front, we make somewhat, for those who aren't familiar with immigration law, especially immigration adjudication, might seem counterintuitive, but we argue that there actually isn't a lot of expertise being exercised by the Board of Immigration Appeals when they're interpreting the Immigration and Nationality Act. And that's because a lot of it doesn't actually even implicate deep questions of immigration policy or of foreign relations or anything like that. And to the extent that it does, we argue that the rulemaking process provides a better way of leveraging the agency expertise. because it involves the legislative council at the agency. It involves the policy experts, as opposed to just the immigration judges and Board of Immigration Appeals judges that are there. So if you're thinking about agency expertise, maybe in some other contexts, you have a much richer type of expertise that's being exercised. But we argue, at least in the immigration adjudication context, it's a pretty weak factor or rationale. Now, I want to just stop and flag that Sid Shapiro has developed over time this kind of craft expertise argument, which I think does have some pull. In other words, these agency adjudicators are reviewing, hundreds of thousands of cases, and with each case, they develop a craft, a better understanding of the statute and regulatory scheme. And so, compared to a generalist court, at least, we might want to defer to them more. And just speaking for myself, maybe not Shoba, that might be true with respect to questions of fact or mixed questions of fact and law in the immigration context, perhaps, but not to questions of law. It really just doesn't, having read lots of these decisions, just doesn't really seem to be, a huge role for craft expertise. So that's expertise. Now, related expertise is process, right? An agency can be much more well-positioned to interpret a statute than a court, or implement a statute than a court, because they go through notice and comment rulemaking, right? They have to sit down with stakeholders and figure out what they're going to do, leveraging the agency's internal expertise to propose a rule. They then release it to the public for public comment, so that public can, and experts that aren't inside the agency can bring their expertise to bear. And then the agency has to go back and reconsider those comments seriously, perhaps do additional research and respond to them. And that process of notice of comment rulemaking really is a much more effective and efficient not necessarily efficient, more effective than a court that doesn't have any type of means for public comment short of amicus brief filings. When you compare that to immigration adjudication, you see there are even bigger problems. Not just because it's you have the same problem you have with judicial review with the court, but we add that there's an additional problem that so many of these non-citizens aren't represented by counsel. They're navigating this process on their own, sometimes not in their first language. And so the extent that you'd even get expertise from anyone other than the agency, than the judges at the agency, it could be really misplaced. So that's on the deliberative process front, something that's worth thinking through. Now, on the political accountability front, there are strong arguments that the agency has political accountability, especially when the Attorney General is the one making the final decision. But on the flip side, our argument isn't that the agency shouldn't be the first mover or shouldn't even get Chevron deference. It's that it should be through rulemaking and not adjudication, right? And so perhaps at most this is a wash, if you're comparing all the Chevron factors. I think it's more than a wash, and Shoba and I explained this in the paper, because from a political accountability perspective, it's not just an election matters, argument. It's also does the public have a say in the process? Does it have salience? Is the agency being held, accountable to the public for its decisions? And if you frame it that way, notice and comment rulemaking again comes out as a far superior approach to making regulatory policy and immigration, at least major regulatory policy. Now, again, we're not arguing you get rid of these other tools. They all play important roles in different situations, even maybe for major immigration policy. Our main argument, though, is that we should shift the default and really go there. And I have to say, I'm thrilled to see President Biden and Attorney General Garland signaling that they're shifting the default, that they're not going to use adjudication to make the major policies, that they're going to be shifting to rulemaking. They've got Cass Sunstein over at Department of Homeland Security working there right now. And I mean, he has to be working on a DACA rule and many other rules that were previously done through guidance. And I think that's a very welcome development as well. So I'm thrilled to see that this administration is taking regulatory policy making quite seriously in the immigration context. Now, I guess I'll stop there and Dick can tell us why we're wrong or maybe why we're right, or I don't know.
Well, I'd love to disagree, but I have to confess I agree with everything that Shoba and Chris said. Let me provide a somewhat different point of entry. I'll start with just first principles that Ideally, the best way to make immigration policy or any other national policy is through legislation. And I give President Bush a lot of credit for having put a tremendous amount of energy into trying to get Congress to enact a comprehensive immigration reform statute. But it's fair to say that his complete failure in that effort, even though he made it one of his major priorities, has served as an object lesson to all of his successors. I don't think any president in his right mind would try to get Congress to tackle this issue today. It's gotten even harder for Congress to enact any form of legislation, and immigration is one of the tougher ones. So, but then that takes us on a search for, well, what's the second best way of making immigration policy? And I'll go through. Well, actually, let me start there with one of the ways that the Trump administration used, which was to have completely unwritten policies. And I can kind of understand the appeal of this. If you have completely unwritten policies, it's very hard to get for the public to challenge them or to quarrel with them because they can't even figure out what they are. And to my dismay, the DC Circuit actually went along with the Trump administration approach on this and said that unwritten policies are unreviewable. So yeah, it's very, very appealing, but horrible for a public policy standpoint. It's hard to imagine any worse way. I mean, nobody knows what the policies are. There's no way of maintaining consistency, zero transparency. There's certainly no clarity. So I'd throw that one out as the absolute worst way of making policy and announcing policy. So then we get to the list of other methods that have been used, not just by the Trump administration, but by prior administrations as well that Shoba went through. And those certainly are better than the unwritten policies because they do provide some degree of transparency and clarity and standards by which performance can be measured in order to maintain some degree of consistency and predictability. But they are horribly lacking in a couple of important characteristics. One is durability. They come from the Attorney General or the President. And if there was any doubt about this before the last 2 years, I think it's all gone now, that those people change. And the new Attorney General is likely to have a completely different perspective, and the new President is likely to have a completely different perspective. So you get no predictability, no sustainability, no durability at all if you use one of these instruments like issuance of a guidance document or an executive order or one of these presidential adjudicated decisions. They're really provide you nothing by way of durability. They also don't provide any political accountability that is sustainable to any degree at all. And rulemaking offers, notice and comment, rulemaking offers enormous advantages over those methods. First of all, even though I would not say that it is as democratic as the legislative process, but it's certainly much more democratic than any of the other policy tools that are available to agencies, because it involves a tremendous amount of public participation, and the courts are pretty good at making sure that agencies take the public participation seriously, and then once the decision is made, usually the downside is it usually takes 2 or 3 years to go through a big notice and comment process. So it takes a bit of time to do it. But what you get at the end is a rule that has had much more diverse public input, that is much more transparent than any other instrument, and much more durable. We're kind of becoming an advertisement for Aaron Nielsen, a very fine administrative law scholar at BYU, but Aaron wrote another very good article in which he talked about the advantage of rules that are issued through the notice and comment process. One of the big advantages is that they're durable. They're durable both because they reflect a lot of public input, and hence tend to be somewhat compromises the way that legislation inevitably always has to be, and hence something that a lot of attorney generals and presidents can live with comfortably for a long period of time. And they're also hard to change. Just as they're hard to issue, they're hard to change. So you wind up with much greater durability and greater accountability, political accountability, because it goes through, if it's a major rule, it's going to go through the organization that Susan ran back in the Bush administration, the Office of Information and Regulatory Affairs in OMB. And that means it will have gotten the attention of really all of the other agencies of government, and they all would have had some say in it. And the eventual sign off is by somebody in the White House who is very close to the president. As one OIRA head once put it to me, I knew I was close to the president when I apparently did something that displeased him, and I wound up with a little nick in my skull from a rock that seemed to come directly from his office to mine. So they're very close to the president, and you get very good political accountability out of the process. So for all those reasons, I always like to have fun quarreling with Shoba and Chris. I don't have any disagreements with them at all on this one.
Thanks, Chris. We're going to now talk amongst ourselves for a bit, but participants, please, if you have questions, I see there's already one in the Q&A. Do put your questions in that or in the chat box, and we'll monitor that. Shoba and Chris, do you have any, are there things that you'd like to respond to that Dick said or Shoba that Chris said?
I mean, I can start. I think that we're all agreeing with each other, but I think that itself is also very telling to the solution here. I did want to pick up on the recent decision Dick mentioned, where unwritten policies are unreviewable, and agree with you that it really creates some pretty challenging incentives for the administration to maybe continue that and avoid judicial review. But just from a view on the ground, many of the unwritten policies that were part of the concerns raised in the complaint were in fact the reality. So for example, one of the concerns were that asylum seekers, both adults and children, were being put through what is supposed to be a threshold screening or a credible fear screening, and instead through a multi-hour adversarial process without any kind of notice as to what was going to be asked, or clarity on what the outcome was, like, did they pass their fear screening? So at the Berks County Residential Center, which was until recently one of the 3 family detention facilities in the United States, it's here in Pennsylvania where I'm based, there were children as young as 4 being interrogated for hours upon hours. There was no written guidance or policy that was given to attorneys if they had one, or to the families themselves. But we knew that there were new policies in place just based on what was being witnessed on the ground. So it's also a good example for, what would it have meant for those unwritten policies to have not only been in writing, but also put through a process and put through rulemaking. The legality or illegality would have been clearer. The opportunity for judicial review, which we already took up court time, right? So how much are we really saving? Would have been clearer. And I think that some of the fairness issues that were raised would have been stronger in their claims.
Yeah, I just wanted to jump in there too. And I think it's something that, when we're arguing for notice of comment rulemaking as being kind of the gold standard in immigration policy, again, I feel like somewhat of a broken record, but I think it's important. That doesn't mean there aren't times when the other tools are really important. I mean, guidance can play a tremendously important role in helping lawyers and folks on the ground know what to do, with respect to regulations that have already been promulgated. And same with adjudication. I mean, sometimes when you have interdecisional inconsistencies in the adjudication system, have an adjudication decision that comes down that tries to help the trial level agency adjudicators rule the same way, it can be really important. One innovation that I really liked that the Biden administration has signaled that they're going to do is, in the Trump administration, as Shoba and I documented in the article, the Attorney General issued a number of really major immigration policies in adjudication. And Attorney General Garland has announced we're going to undo those in adjudication. So we're going to set aside those policies, but we're going to provide we're now going to go through notice of comment rulemaking to figure out what is the best policy with respect to each of those issues. And I think that's a really, Shoba and I were talking about this the other day. I was like, I wish I had thought of that when we were writing our paper of because one of the kind of big arguments against our idea of notice of comment rulemaking being the default is, well, that locks in the prior administration's, major policies for years, or at least for a year or so. And not necessarily, right? I mean, this Justice Department has made it pretty clear that they can undo those policies through adjudication, but they're going to do the serious hard work of figuring out what the better policy is through rulemaking. I think that's something that, that can be, be applauded, and it's a tool that can be used by future administrations as well.
So wearing my former OIRA hat, you all made excellent points about why notice and comment rulemaking is more transparent and politically accountable. One thing you didn't mention is the requirements for the analysis to support the regulation, and that is OIRA wears several hats. One of them is coordinating across the government, and Dick made that point. But another is ensuring that agencies have thought through what will the benefits and what will the cost be. So in adjudication, you're looking at an individual case, but if you're making broader policy, is that something that you think is important, or would it be just too hard to do for immigration cases anyway?
I mean, maybe Shoba and I might have different takes on this, which is fair, which is one of the fun things about co-authoring.
We need some disagreement on this panel, Chris.
I mean, so we didn't, in our article, we didn't touch OMB review at all. And part of it was we were really short on words, despite it being over 45 pages. That it grew, but those editors kept us pretty close to our word limit. But I think there's tremendous benefits that come from rulemaking by 12866, the requirement for not just economic analysis, but the rest of circular A4 of really looking at what are the unintended consequences, what's the baseline we're regulating against, what are regulatory alternatives that might be more cost effective or might produce more benefits, net benefit. So I view that as a huge plus in the immigration adjudication context. Now, there are the common criticism about cost benefit analysis and how it's hard to quantify. I do kind of wonder, and I don't know, Susan or Dick, if you have thought, or Shoba as well, because thoughts of, with the new Biden modernizing, regulatory review executive order that came out the first day of his administration, where it said that, in addition to doing everything else that you normally do, I want all agencies to focus more on the effect this has on marginalized communities, the effect this has on climate, the effect that this, really kind of sending a progressive vision for cost benefit analysis. I wonder how that would play out here. And I haven't seen any developments yet. Maybe I've missed them. I don't think the Biden administration has really told us what that executive order means. That doesn't surprise me. I mean, he charged agencies to innovate and come up with ideas. But I do wonder how that would play out in the immigration context. And my guess is it would help align that kind of thoughtful, cost-benefit analysis process in a way that's more consistent with what President Biden was elected to do. I don't know. Shoba, I'll stop there and you can push back, which is completely fine.
Yeah, no, I haven't either seen a lot about how it might affect immigration policy. There's certainly a broader conversation about the neutrality of immigration law and policy and how it, because of its framework, affects marginalized immigrants. But I think that the jury's still out on what the relationship is going to be between that charge and immigration policy in the future.
Yeah, offhand, I don't really see much of a nexus there. I think there are many other contexts in which those two factors, equity considerations and effects on disadvantaged communities and climate change are certainly going to be relevant factors, and you can see how that emphasis could play out. I don't see it happening much in immigration.
Yeah, I read in the memo that distributional impacts to really do a better job of looking at who is bearing the costs, who is receiving the benefits. So it's how that's distributed, and I can see that being important in this area. Are there other comments you have on each other? We have a couple questions in the Q&A and one in the chat.
I've got other stuff, but maybe let's go to the questions first, and then we can, if we can circle back.
Okay, the first one that I saw was in the Q&A. I think I'm going to have these in the right order. I apologize if I don't have the order right. So from Christopher Melling, does national security often arise in the immigration context as a reason not to conduct notice and comment rulemaking? If so, what are some of the common arguments used and how would you counter them?
I might start and then I'll leave it to Chris and Dick to correct me or disagree with me. I would go one step further. National security, in my view, has long informed immigration policy and long been a proxy for immigration policy, not just in the rulemaking context or as a method to avoid notice and comment rulemaking, but even in the rulemaking context, as we saw, for example, with the 9/11 registration programs, where a rule was published in the Federal Register for certain men from certain countries, all Muslim majority except for North Korea, to visit an immigration office and be interrogated and fingerprinted and photographed in ways that no other visitors were. But to the specific question, yes, national security has been used. I've seen it most often when using good cause or the foreign affairs exception as a reason for why the agency is not in a position to engage in notice and comment rulemaking. Not every argument has been solid, in my view. In fact, some may say, and the foreign affairs exception is another reason, without actually having a detailed explanation for what that foreign affairs exception is. In the last administration, there have also been a nexus made between, what might be occurring at the border or emergencies at the border and issues of national security as a way to bypass a notice and comment rulemaking. So some of the counter arguments to that might be that to kind of dismantle that nexus, if there is in fact fact-based analysis to show that, for example, what is taking place at the border hasn't changed in 10 years or 20 years. So there's time, right? There isn't an emergency in the way that you must avoid notice and comment rulemaking. Another counter argument is if there's no explanation at all, at least with respect to the transit rule, which was the second interim final rule I mentioned that made someone ineligible for asylum if they were in a third country before arriving at the border. That was eventually an interim final rule that was vacated for failure to go through notice and comment rulemaking. The agency appealed it. It's still pending, the government, excuse me, and then the government re-promulgated the rule through notice and comment, with notice and comment. So that's a little bit of my response to your question, and I'd love for Chris or Dick to add.
Yeah, let me just jump in real quick. So I think in the adjudication context, Shoba and I, we don't see it as much, right? I mean, like a real national security type argument. I think Shoba's examples are right. It's much more when they're deciding between rulemaking and notice and comment rulemaking and interim final rulemaking or guidance or executive order. But that's kind of one of our arguments, right? In the adjudication context is people raise, expertise in national security or foreign relations, but if you look at the actual statutory ambiguities at issue, it's seldom, if ever, what's really there. I did want to flag, and I put in the chat, Patrick Glenn, who's been at the Justice Department for decades, working in Office of Immigration Litigation and elsewhere. He wrote a response to our piece that's kind of was like, "You're not right," which I loved, and you should all definitely read it. I wish we had gotten it before we finished writing our piece, because I think some things we'd respond to a little bit differently. But I do think one of his main arguments is somewhat along the lines of that question of, this is one area we think that the president should, presidential power should be near its top, right, when you're dealing with immigration. And I think that's fair. Our response is the president still has this power. It's just rulemaking is the better regulatory process to use. But I do think that's part of it. On the national security issue in particular, I don't. Interim final rulemaking has its role, right? If there really is a national security issue, of course, like the president, the attorney general, the secretary of Homeland Security, whoever's charged under the statute, can use that tool. I guess Shoba and I are probably on the same page, although we don't write about it in the paper, that it's vastly overused in the immigration context, abused, and quite frankly, I think it's abused across the administrative state. And Kristen Hickman and others have written pretty extensively about the abuse of interim final rulemaking.
Yeah, I'll just add a couple of points here. One is I agree with Chris's take that I think it's quite rare, if ever, that concerns about national security issues should deter an agency from using rulemaking in a context of this type. In this context, it seems to me the biggest concern that you'd have is to make sure that no terrorist sneaks in through this process. And that's really easy to address. There are, to my knowledge, there are at least 2 terrorist watch lists that the government maintains. Now, they have a bit of a problem, as the Supreme Court actually pointed out in a case that decided at the end of its term that the names are often names that more than one person has. I've got a friend who has a client name, would you believe it, Saddam Hussein. He happens to be a very good car salesman, and he doesn't even have any roots in Iraq, but it's very hard for him to return to his native country and for a funeral or a wedding and then come back into the U.S. He still gets stopped, and people say, the border security people say, "Oh my goodness, we thought we got you." But what is very easy to do is establish a system, and I'm sure it's there. I'm glad nobody's told me it's there, because it should be secret. where the security agencies get the lists of the applicants, and they compare them with their terrorist watch list, and then do whatever is necessary to find out, is this the Saddam Hussein or the one who sells cars in rural Virginia? So I think that's really the only serious national security concern. And I think it's very easy to address in ways that I'm sure the intelligence community is now already addressing it.
Thanks, everyone. I'm going to read another question from Alexander Glover. How does current immigration policy affect interpreters, the U.S. military employed in places like Afghanistan and Iraq? One example making the news would be Zalma Niazi, who currently faces deportation due to an interaction he had with the Taliban as a child. Are there provisions with foreign nationals who served us in the theater? Shoba, do you know the answer to that?
So yeah, this is not an issue I have followed closely, nor my sort of focused area of expertise. So with that caveat, we do have legislative provisions in place for certain interpreters. One category is called the special immigrant visa. I know there's been more attention being paid to relax those requirements now so that interpreters are able to more quickly enter the United States through that legislative vehicle. You know, in terms of people who are already here, who face deportation post-entry, we have very broad provisions, very lengthy provisions in our immigration statute that make people deportable for national security and terrorism related reasons. And whether, what that interaction with the individual example looks like may very well matter. I guess the final option, having not explored what options are already being explored by the agency in this emergency situation, may be something outside of rulemaking, right? Like we have all been talking about situations where rulemaking may not be, the best option when the timing really matters, or there's an emergency situation. There's a tool in immigration law called parole, which is synonymous for entry. It is a provision that could allow individuals who are in danger to enter the United States lawfully, even though the entry itself would not be an admission, formally speaking.
Anybody else on that one? We have another question on interim final rules. What about the problem with DHS and INS issuing major regulations as interim that remain in place for decades? Each sectoral has a defense of standing, which is entirely a political doctrine as practiced by the courts.
Yeah, I mean, I think I somewhat covered this already. I think it's abused. It's interim final rulemaking is provided in the Administrative Procedure Act. If you can show cause, I think what we consider cause has been misconstrued. I think courts should construe it much more rigorously, and it's abused, and not just in the immigration context and others. I'm not sure about the standing point. I mean, as Shoba mentioned, I think in her introductory remarks, the plaintiffs have done a pretty good job at stopping two major interim rules that were issued by the Trump administration in the immigration context. And so I think you can still challenge them. That's not the issue in my mind. The bigger issue is that it just doesn't use notice and comment rulemaking, right? It doesn't leverage public expertise. A lot of times it doesn't even leverage agency expertise. I haven't read a lot of these. And I was trying to Google it to find Kristen Hickman. Kristen Hickman and Aaron Nelson should be on here. I mean, we've mentioned them more than anything, but Kristen's got a great article.
Look, Aaron was. Maybe Aaron can jump in here.
but Kristen's got a great article on this where she kind of surveys the land of interim final rulemaking and makes some pretty I think important suggestions about how to reform judicial review to give the right incentives to agencies.
So I think that same person says you could spend 5 years litigating standing even before you get to the notice and comment issue. So there's Aaron, I don't know if you do want to jump on and say something. Nate would have to unmute you, I guess. I do have one more question in the Q&A, so please, if you have another question, submit it or raise your hand and Nate will call on you. All right, I'll pose this last question that we have. Should there be better monitoring of supervised release of defendants who are deported? It seems the policy is to do nothing until defendants are arrested after they've re-entered illegally, maybe numerous events of entry. So Shoba, that's another policy question, so maybe that goes to you again.
Yeah, so that's a pretty big question, right? If I could situate it in this conversation, should there be rulemaking for somebody who has been ordered deported? I haven't thought about that specific question or what, and also what the incentives would be for the government, because that also sounds like that would be a cross-border policy that would involve costs and raise some efficiency concerns. So I would really want to examine the cost-benefit analysis of having a policy. And I can say, just as a policy matter, those who are removed and re-enter represent a very diverse population. So just the basis behind why people re-enter is not one size fits all, but that's a policy conversation for another webinar.
Yeah, the only thing I'd add to that is that this is really a how do you allocate scarce resources issue. There are people that the U.S. deports and then monitors very carefully wherever they go. But there aren't that many because we don't have an unlimited number of intelligence agents who can run around keeping tabs on people. And most people who are deported, there may be very good reasons we'd rather not have them in the country, but they don't pose much of a danger to the U.S. Those that are believed to pose a big danger to the U.S. are monitored. They're just monitored in ways that you and I don't know about and shouldn't know about.
I do think it's interesting to, again, I know nothing about the policy, not going to go there, but I did like Shoba's comment, if we are going to do more cost benefit analysis and think of more rulemaking to address issues, which I'm not sure how rulemaking would work here, but just assuming it did, it would have results that would be, I think, really informative to the to the policymaking process of, especially on the cost benefit side. My guess is that with limited resources, the government might in some ways even do less on that front, and that would have a greater net benefit. I don't know, just kind of throwing that out there, but I'm really curious to see how this will play out more, particularly how it's going to interact with Biden's approach to regulatory review.
Yeah, so benefit cost analysis of immigration policy writ large and which approaches might be the most effective, given different goals. Oh, there's another Q&A. Nate, is there anybody who has raised a hand? Okay, Leo Connor has a question. Oh, she has not a question, a comment. I might have misheard, but I thought I heard an earlier speaker refer to President Trump's early ban on countries as a Muslim travel ban. This is a frequently used term, and it is a calumny. Did I pronounce that right? The ban was on travel from countries whose governments were such that the identities of travelers could not be confirmed. Many largely majority Muslim countries were not affected. Only those with no or poor recording, which happened to be majority Muslim.
Well, I guess all I can say is I've done a lot of research and writing in that on the various iterations of the travel ban, and that characterization I think is reasonably accurate as to the third travel ban, the one that was upheld by a divided Supreme Court. I do not agree at all with that characterization of the first and second travel bans. They were frankly just pure crap. It was based on nothing but a gut feeling that Muslims were bad, and the gap between the conversation that the president had with Rudy Giuliani, in which he asked him, "How can I ban Muslims?" And the issuance of the first of the three travel bans was very brief. I don't have any doubt what that was all about. But the third, I agree with the characterization of the third, and that, of course, is why a majority of Supreme Court justices upheld the third.
All right, I think we are at the end of our time. Does everybody want to make some concluding remarks? We'll start with Shoba, and you don't need to if you don't want to.
Just wanted to thank my panelists and you, Susan, for moderating, and also for our questions and comments. I think that, you know, it could be a whole day the next time we have this conversation, so we can talk both about substantive policy and also notice and comment rulemaking as procedure. And I'm looking forward to that conversation.
Yeah, I would just add my thanks. Also, just, you know, and Dick mentioned this, especially since there's no congressional action, immigration law and policy is going to continue to be administrative law, right? I mean, like, this is some of the most fascinating issues that we're going to be dealing with from a regulatory process and administrative law are going to come from immigration. And I've seen in the classroom of students that immigration law is also drawing students towards administrative law. And so it's kind of this feeding back and forth. And I just hope that we do more things, more conversations like this, where we bring administrative law and immigration law experts together, because there's so much we can learn from each other about immigration law and about administrative law. So I'm really excited to see us do this today.
Yeah, me too. Dick, any concluding remarks?
No, all I'd add, I guess, is there are a lot of difficult questions in this field, no question about it. People of good heart and mind can sit and talk about the merits, not the procedures, but the merits of immigration law for a long time, and have really sincere disagreements about very serious questions.
I'd like to thank Nate and the Regulatory Transparency Project and everybody, all the great questions that we got from the participants. Nate, are you able to give us some verbal closing remarks, or?
Hopefully this time. Apologies to all for the initial issues, but really grateful to Susan, Dick, Shoba, and Chris for a wonderful conversation. We very much look forward to having each of you back again with us soon. To our audience, we certainly welcome your feedback at rtp@regproject.org. Thanks to everyone. Have a great day.